We're here today to make one thing clear. The Trump administration cannot hide conditions inside the Otay Mesa detention facility. If they will not allow a lawful public health inspection, a federal court will. This morning, San Diego County filed a lawsuit against the Department of Homeland Security, ICE, and CoreCivic, seeking a preliminary injunction to allow our public health officer to conduct a full inspection of the Otay Mesa detention facility. California state law gives local public health officers the authority to inspect privately operated detention facilities like Otay to protect our public health. This is our job. This authority exists for a reason. Diseases and unsafe conditions impact those inside the facility and do not stop at locked gates. Staff, contractors, and visitors move between that facility and our community every single day. For months, we have heard troubling reports from inside Otay Mesa, including untreated medical conditions, freezing temperatures, and contaminated food. These allegations must be investigated. What occurred a few weeks ago was not an inspection. We were denied medical records, we were denied private interviews with detainees, and we were denied the information needed to evaluate health conditions inside the detention facility. Chair Pro Tem Paloma Aguirre and I were also blocked from entering the facility after the local ICE office had previously cleared us to participate in this lawful inspection. Transparency and public health oversight are not optional. They are the law. We are asking the court to act quickly so that our public health team can conduct a full and unobstructed public health inspection. Now, I turn the floor over to Board Chair Pro Tem Paloma Aguirre.
Thank you, Madam Chair. Good morning, everyone. I'm Supervisor Paloma Aguirre, representing District 1, where the facility is. I stand here with Chair Lawson-Remer and County Counsel Damon Brown to officially file a lawsuit in federal court against the Department of Homeland Security, ICE, and CoreCivic. Buenos días, soy la supervisora Paloma Aguirre y estoy aquí junto a la presidenta Lawson-Remer y el asesor jurídico Damon Brown para presentar oficialmente una demanda ante un tribunal federal contra el Departamento de Seguridad Nacional, ICE y CoreCivic. This lawsuit enforces our legal right to access the Otay Mesa Detention Center for a public health inspection. San Diego County is responsible for protecting the health and safety of everyone within our borders. That responsibility does not disappear because a facility houses immigration detainees or because it's operated by a private for-profit corporation under federal contract. Esta demanda exige nuestro derecho legal de acceder al centro de detención de Otay Mesa para realizar una inspección de salud pública. El Condado de San Diego tiene la responsabilidad de proteger la salud y la seguridad de todos los habitantes que viven dentro de nuestras fronteras. Esa responsabilidad no desaparece simplemente porque una instalación albergue a detenidos de inmigración o porque sea operada por una corporación privada con fines de lucro bajo un contrato federal. When credible reports reveal unsafe health conditions in a public facility, the county has both the legal and moral responsibility, but most importantly, the legal authority under California Health and Safety Code Section 101045 to act. Unfortunately, what we're seeing today reflects a broader pattern under the Trump administration, where federal agencies are increasingly blocking transparency and oversight, even when public health is at stake. The Otay Mesa Detention Center is located in District 1, my district. The families who live in South County deserve to know what is happening inside this massive federal detention facility operating in their community. Lamentablemente, lo que estamos viendo hoy refleja un patrón más amplio bajo la administración de Trump, donde las agencias federales bloquean cada vez más la transparencia y la supervisión, incluso cuando la salud pública está en riesgo. El centro de detención de Otay Mesa se encuentra en mi distrito, el Distrito 1. Las familias que viven en el sur del condado tienen el derecho de saber qué es lo que está sucediendo dentro de la instalación de detención federal por el bien de su comunidad. In late February, as the chair mentioned, San Diego County scheduled a public health inspection of the Otay Mesa Detention Center more than a week in advance. ICE officials confirmed in writing, as she mentioned, and we were cleared to enter the facility as part of our inspection. But when we arrived, we were told ICE leadership had not cleared the inspection. Let me be very clear. This is not a decision made by local staff at the facility trying to do their jobs. This reversal came from national ICE leadership in Washington under policies shaped by the Trump administration. And although our county public health officer was permitted inside with very limited access, basically just to look at a kitchen and 2 medical bays, they were denied access to medical records, facility health policies. They were denied access to medical records, facility health policies, and confidential interviews with detainees, basic information needed for a legitimate inspection. This was not a misunderstanding. It was a deliberate decision by federal officials and a private prison company to block public health oversight. I want to once more reiterate that this inspection was not scheduled at random or to cause operational disruption. It was prompted by several reports of unsafe conditions inside the detention center. I want to share with you just a few of the list of examples we have received. Published on Cal Matters July 14, 2025, they reported that a deaf asylum seeker held at Otay Mesa Detention Center spent more than 4 months without a qualified sign language interpreter, leaving him unable to communicate during legal proceedings, medical evaluations, or daily interactions, described by his attorney as the equivalent of solitary confinement. Published by KPBS on July 28, 2025, reported overcrowding detainees falling ill with delays in medical care and cases escalating to hospitalization. NBC7 reported on February 6 a detainee threw a note attached to a lotion bottle over the fence describing bad food and constant sickness. The International Business Times reported former detainees described harrowing conditions, including confinement in cage-like spaces just big enough for a chair. They also reported constant illness, cold temperatures, and lack of food. And so on and so forth goes the list. These are not minor complaints beyond the public health risk. These reports reveal a complete disregard for basic human rights and dignity. The county's responsibility in the face of these concerns is very clear. Conduct a full health inspection. And yet, instead of cooperating with a legitimate public health inspection, federal officers under Trump chose secrecy over transparency. San Diego chooses accountability. We will not allow oversight to be blocked. Not even the revolving door of unqualified personnel and leadership changes will slow us down. The Trump administration may be comfortable operating behind closed doors. The Trump administration may be comfortable operating behind closed doors, but San Diego County is not. When Washington refuses transparency, we assert our legal obligation to protect the health and safety of everyone within our county's boundaries. We will exercise our lawful authority and walk through those doors to conduct a full public health inspection. And with that, I'm happy to turn it over to General Counsel Damon Brown.
Good morning. Today, my office filed a federal lawsuit against the U.S. Department of Homeland Security, Immigration and Customs Enforcement, and CoreCivic to enforce the county's state-authorized health and safety inspection rights at the Otay Mesa Detention Center. This case is about ensuring that the county can carry out its legal duty to protect the health and safety of people housed and working within the facility and the broader community that depends on us to do so. The complaint that we filed asserts 3 causes of action, each grounded in federal and state law. The first is under the Administrative Procedures Act, where the county alleges that DHS, ICE, and CoreCivic have engaged in final agency action by refusing to allow the inspection, and that this refusal is not in accordance with federal and state law, including California Health and Safety Code Section 101045. The complaint further alleges that the defendant's decision is arbitrary, capricious, and an abuse of discretion because they have provided no reasoned explanation and ignored essential statutory requirements and cooperative federalism principles. The second claim is also being brought pursuant to the Administrative Procedures Act, where the county alleges that the defendants have unlawfully withheld and unreasonably delayed granting access, despite previously clearing the inspection team and despite the county having no other available remedies to gain access. This is an ongoing refusal, and it continues to cause harm for which no other remedy is adequate. And the third claim is for declaratory and injunctive relief, where the county seeks judicial declarations and injunctions confirming its inspection authority under California Health and Safety Code Section 101045 and compelling the defendants to allow the inspection to proceed. The complaint states that the defendant's refusal is an ongoing violation of federal and state law that is causing irreparable harm. And so, consistent with the complaint, the county is seeking both preliminary and permanent injunctive relief, and we're preparing a preliminary injunction motion that we expect to file this Friday. That motion will ask the court to order immediate access to the facility so that the county can complete its inspection without further delay. We're also asking the court to advance the trial on the merits and to consolidate it with the preliminary injunction hearing, as authorized under Federal Rule of Civil Procedure 65. This will allow the court to resolve the county's inspection rights on an expedited basis. An entity operating within San Diego County must comply with state health and safety laws, and no entity is exempt.
Thank you all very much. We're now available for questions. Yes. I'll turn that over to Damon. The question was a detailed recounting of the refusal since last week to allow us in on Friday as requested.
So we had communicated with the facility and with ICE that we needed to be allowed into the facility, and that was the date, the Wednesday date. Last Wednesday was the deadline we'd given them to confirm our access last Friday. They did not meet that deadline. Instead, they responded late Thursday evening asking for additional information seemingly under the pretext that would allow the access. However, this information is not relevant and not required under the statute to provide us the access, and we affirmed that in writing to them that we would proceed to advance our rights to pursue the inspection. And so that has been the communication since that time. It was a series of some of it was duplicative of information that we'd already provided them. They had asked us to summarize the standards by which we would be inspecting the facility. They asked us for a time frame of the time it would take us to complete the inspection. Again, these are things that are not required under the statute for us to provide. And they also cited that because of the government shutdown, they had some concerns about being able to allow the inspection to continue. However, again, that is not a basis for refusing the access. In fact, the facility, ICE, has received a separate contingent of funding from the government to allow it to continue to operate despite shutdowns. And so that would not be a valid basis for prohibiting the inspection from going forward.
Please. I continue to believe and hope that we live in a nation that's governed by law, where at the end of the day, when the court makes a determination on legal authority, that everyone must obey that legal order. And if we lose hope that our nation is governed by laws and not arbitrary and capricious demands, we are in a very, very bad place. Our case is extremely strong on the merits, and the leadership at the helm of the agency is not going to impact that one way or the other. Other questions? Yes. Do you want to go?
If I remember correctly, we received clearance on Wednesday or Thursday?
Wednesday.
So we received clearance on Wednesday, and it wasn't until the moment we were allowed into the lobby that we were told that that no longer was the case. So it was very last minute.
No. Yeah, sure, absolutely. She just asked, when were we denied entry into the facility? And my colleague reiterated that we had been cleared, we were cleared to enter, and that denial of entry did not occur until we had reached the facility on Friday. Why don't we both answer that? So let me just start, and then I'll turn it over to my colleague. First of all, the notion that a government can hold anyone without oversight is a terrifying idea. The notion that we could have a police force operating under the authority, direct orders from the President of the United States to arbitrarily lock up whomever they want, and there is no oversight to ensure that those conditions are humane, is incredibly scary. It undermines the core principles of freedom and civil liberties that America is built upon, and is a direct frontal assault on basic principles of human rights and basic principles of being treated with dignity and respect. Individuals in these detention facilities are not criminals. They've not been prosecuted and convicted of crimes. They are awaiting processing. It could be you. It could be me. It has been our neighbors. It has been our friends. And it will be our neighbors, and it will be our friends over and over again. And these stories are not one-offs. They have become a pattern of this administration. So to say that you are sure you'll never be detained, I think is a very fundamental misassessment of what is currently going on in this country. And I will say, I speak on this issue as a person of Jewish descent who will never forget I talked to my grandparents. We have family stories about people who barely escaped a Holocaust in a country that was apparently ruled by law at the time. And then individuals were just arbitrarily detained, and nobody inspected, and nobody cared, and nobody watched, and everyone shut their eyes. And then that's what happens. So this is about rights and liberties and human rights and standing up for rule of law and protecting basic principles of democracy and freedom.
And I'll add to that our constitutional rights are being violated. Our they're not observing legal due process. And we know that some of these folks have been detained for months without any due process, with no basis whatsoever. Now, in addition to that, I think that what falls squarely under our responsibility and jurisdiction is public health. And it should worry all of us that the basic inspections that we have a mandate to conduct under our public health authority are not being allowed. That should worry everyone, because communicable diseases are a real thing. And unless we know that conditions are sanitary enough and providing safety and health for the detainees, that could very easily become an issue or a problem or even a threat to all of us within the county. So we know that there are a lot of different illnesses that we have been identifying. Recently, you've heard in the news tuberculosis, measles, and other types of diseases. So unless we have the ability to exercise that basic authority, nobody else is at the wheel. That's why we're fighting so hard for all of you.
Wait, sorry, say this again. Is it possible in the future could any Congress member, is that the question? So I just want to clarify, this is a state cause of action, right? This is state law. We have the Public Health Authority as the public health agency and the lead on public health oversight in the county of San Diego. And we have not just the right, but also the obligation to inspect this facility, among other detention facilities within our jurisdiction, to ensure compliance with basic health and safety guidelines. Congress has a broader but different oversight authority and mandate from Congress, and there is and continues to be ongoing active litigation by congressional leadership and congressional members to enforce that oversight responsibility. But these are distinct responsibilities and distinct litigations. Yep. Thank you. That's a great question. Our core competency is in extensive documentation, conducting fact-finding, conducting interviews, looking at medical records, comparing those medical records to the reports of detainees, comparing policies and practices to the reports of staff regarding operations inside the facility. We have a deep expertise and a core competency in doing exactly these kinds of inspections and producing these kinds of reports. If we did find violations, we would then publish this report, make it publicly available, which would then potentially provide grounds for another agency that has supervisorial oversight power over the detention facilities, namely Congress, to be able to then act on potentially shutting down the facility or other more aggressive actions. So we are the fact finders. We would then provide the factual basis for further legal enforcement and supervisorial action by other agencies and entities. Other questions? Okay, we're available for one-on-ones, and if you would like to do some one-on-ones in Spanish, please talk to my colleague, Chair Pro Tem.